Hello guys, welcome to Koi Academy. Guys, in this video, we'll be talking about a very important topic in Contract Act, and that is consideration. Now, consideration is defined in Section 2, Clause D of Indian Contract Act 1872. Now, we all know that consideration is when something is done in exchange for something, then that is consideration. For example, if Mr. X is selling his car and Mr. Y is paying $25,000 for that car, then for Mr. X, that consideration is the car, and Mr. Y, for Mr. Y, the consideration is $25,000. That is, they are offering each other something. Now, remember that there are certain elements which need to be there in order for a consideration to be valid. Remember, if the consideration is not valid, then the contract is not valid. Contract is void. So what are the scenarios? We will discuss each of these in detail as to what constitutes a valid consideration. So number one is that consideration must be at the desire of the promisor. Now, any act or abstinence shall constitute a good consideration only if it is done at the desire of the promisor. Now, if for example, Mr. Y in our case is giving $25,000 to the promisor, then which is Mr. X, then that should only be considered a good consideration if it is in response to Mr. X offering him the car. Now, if he's paying $25,000 for no good reason, then that is not a consideration because it is not at the desire of the promisor. Number two is that consideration may move from promisee or any other person. Now, this is a very unique characteristic of consideration, and people often confuse it, or even they don't even believe it. That let's suppose Mr. X offered Mr. Y the car. Now, it is not necessary that Mr. Y has to give $25,000 to Mr. X. The only thing that needs to be present in a contract is that there is consideration, and in our case, the consideration for the car is $25,000. Mr. Y pays $25,000, or somebody who is not part of the contract pays $25,000 to Mr. X. That is good enough. Now, this principle is often called privity of consideration is not required in a contract. This means that those parties who are not those people who are not parties to a contract, they can also furnish consideration. Now, that will also be considered a valid consideration. Number three is consideration must be real. Now, consideration needs to be something tangible of some value. Let's suppose that Mr. X said to Mr. Y that I will, or Mr. Y said that if you give me car, if me give me your car, I will bring stars for you. Now that is something unreal. That cannot happen. So that consideration has no value. It is abstract in nature. So that is not going to be a valid consideration. And even if Mr. X delivers the car to Mr. Y, and later he does not get any consideration or any stars, so to speak, then that will not be a contract enforceable by law. That is, Mr. X cannot take Mr. Y to court because originally the consideration was not valid and there was no contract at all. Next is that consideration need not be adequate. Now, this is also a very unique point in Contract Act, and it says that there is only, for a contract to be valid, the consideration only needs to be there. It needs not be adequate. Now, for example, Mr. X was selling the car, and in return, let's suppose he agreed that I will sell your car for $2,000 instead of $25,000. Now, that is a contract as good as anything, because Contract Act states that consideration only needs to be there. It does not have to be adequate. Now, there is a caveat here that let's suppose Mr. X takes Mr. Y to court down the years that your consideration was not adequate. You only paid me $2,000, whereas my car was worth $25,000. Now here, court will determine as to whether Mr. X agreed to $2,000 under duress, that is, he was forced to accept that, or did he accept those $2,000 freely without his free consent. Now, if it was under duress, that is, Mr. X was forced to take $2,000, then that consideration will be revised by the courts. They will ask Mr. Y to give remaining $23,000 to Mr. X because the consideration was not adequate. So then there will be a remedy for Mr. X. The next is that consideration may be in past, present, or future. So let's suppose that Mr. X says to Mr. Y that, or Mr. Y says that since I paid you $25,000 5 years back, you can now, why don't you just give me your car and we will call it a spade a spade. Now, that can also act as a consideration. That is, Mr. X has to deliver the car now, but Mr. Y already paid his consideration in the past. That is, 5 years ago, he paid $25,000 to Mr. X for any reason. So, that is past consideration. Present consideration is when both the parties will perform their promise in the present, and future is when either one party will perform the promise in the future. Next is consideration must be lawful. Of course, you cannot say to somebody that I will give you my car, but only if you murder somebody else. Now, that contract and consideration will be unlawful because murdering someone is illegal. Then there is the last is that consideration should not be immoral or opposed to public policy. For example, if you're signing a contract of employment with your employer, and employer says to you that in addition to $25,000 salary, you will also sign in the contract that you will not get any medical leave from me. Now that is against public policy. That is against the fundamental rights of people. So that is not a valid consideration on the part of the employer. So that contract will be void. It will be void. It will have no legal enforceability. Another example could be that let's suppose the employer forces the employee to sign the contract and tells him that you will not be part of any trade union. Now, if in your country the trade unions are not banned and they are perfectly legal, then that consideration is illegal because you cannot ask your employee to sign a contract wherein it says that you will not be part of any trade union because trade unions are perfectly legal in your country. So that will also be a invalid consideration, and the contract that will result from as a result of that clause will be a void contract. I hope you learned from this. Do comment and share and subscribe. Thank you so much.